Kanun is up next in our broadcast agenda today. Host, the famous and popular attorney Raja Bhandari from the law offices of Raja Bhandari and Six and Settlements. Attorney Bhandari's point of discussion this afternoon is how does a trust avoid probate? Let's find out.
Good afternoon. This is Raja Bhandari from Six and Settlements, Raja Bhandari Law Offices of Annandale, Virginia. Welcome back to Kanun. Friends, it is so nice to see you again. Let's talk about the trust. Last time we were talking about how you can avoid completely probate section of the code when you have a properly written, properly executed trust, revocable trust or any other trust for that matter. Now, this is how it happens. When you prepare a trust, we were talking about we have two trusts, revocable trust, one for husband, one for wife, and they are the trustee of their own trust. If husband dies, everything goes to the wife, vice versa. And if something happened, then we appointed two of their children as a successor trustee. They are over 21 years of age, and then they are also successor trustee as well as the beneficiary, so they can distribute. Now, the key question in this one is that you have to fund the trust rather. When you fund the trust means that if you have a real estate property, we usually take from your individual name, put it in the name of trustee of the trust and record that in the land record where your property is situated. And the second thing is that if you have a bank account, you make the trust beneficiary, and if you have 401k, life insurance, either you can appoint the beneficiaries, your children, or you can bring them in the trust as a beneficiary. So that means that everything you own while you are alive become a property of the trust. Obviously, who owns the trust? You own the trust, and you are the trustee of the trust. You are the beneficiary of the trust during your lifetime. So it's basic. And let's say that a question comes that I have a question that can I sell my property even when I transfer that property to the trust? Of course you can do that. It's a very simple way of doing, because you will be signing the deed to the buyer as a trustee of the trust, and then we prepare the deed in a way that is recorded in the court that we give full powers to you and as well as to your successor trustee. The title company or the attorney who is going to do the settlement has to see the trust agreement, and then it's there. They will say that's fine, no problem. So this is how you can dispose of. If you want to buy a new property, yes, you can buy a new property and transfer that to trust again, the way you did it for the first one. So this is how you have to fund the trust. That is the important issue. Making a trust is just a simple document sitting over there. You have to, there is a tool. You have to make that tool work for you, so you can save a lot of taxes and hassle, as we discussed before. Now, when you fund the trust, this is how the distribution. Now, when let's say that you don't have a trust, you have a will, that has to be probated. But when you have a trust, you die, but trust does not die. Trust has a successor trustee to dispose of according to your wishes. So, for example, if you die, everything goes to your wife. A wife dies, everything goes to you. That's what you created that trust. If something happened to both of you, you are mentioning in the trust that my two kids are the beneficiaries and they are the successor trustees. Means they have the same power as you, and then they can dispose of the property, divided among themselves, whatever the way they want to do, and file taxes afterwards when they dispose of that. Of course, you can talk to the tax accountant regarding the tax issue on that. However, but obviously you have to file the taxes no matter you own individually or by the estate. Doesn't make any difference. Even when you have, that's what I learned from the friend of mine from the tax situation, that you pay less taxes when it comes to capital gain if it comes from the trust. We will ask that Manny about that question, but at the same time, that's what I learned about it. However, so when trust does not die, if you die, so then after that, successor trustee comes in picture, distribute the property as long as it is funded. Now, question comes, you own two houses, and then you put it that in the trust. and you have a bank account which you did not make that beneficiary, the trust beneficiary, that is not going to go anywhere. You have a pour over will in your estate planning. So that way, obviously, you have to probate that part of that particular assets in the probate section. That is why we recommend each and everyone, please fund the trust. So when you fund the trust, become the trust property, and it's very easy for the beneficiary as well as successor trustee to distribute without going to a court section of probate. So you can imagine the hassle you can save, you can imagine the taxes you will save, imagine the, and there is nobody can contest because nobody knows that, because once you open the estate it becomes a public record. But in this case, of course, I mean, nothing is foolproof, anybody can file a claim, but at the same time it is very easy to avoid those kind of hassles in this particular matter. I will be discussing more questions on the trust that I received from you, but in nutshell, this is the trust picture that I am trying to create in front of you. So if you have more questions, then you can send it to me, but in coming weeks I will be taking lots of questions on the trust, that how it is beneficial, how it can save a lot of money, how it can save a lot of hassle, and at the same time that you as a trustee and beneficiary of your trust, how it is beneficial during your lifetime and how it's beneficial after you die for your children. So friends, do not forget, if you do not have a will, fate is in the hands of state. So long.